What would rape trials look like if we, quote, believe survivors, as we're always told to do? Well, they'd look like the judgment against Mustafa Ururyar, a Toronto graduate student who has been convicted of raping fellow graduate student Mandi Gray in a case in which the worst thing Ururyar did was believe that his casual girlfriend's promise of hot sex, which she sent to him in a text, was still in force a few hours later. That's my subject on today's Fiamengo file. I'm Janice Fiamengo of the University of Ottawa. In late July of 2016, Mustafa Ururyar was convicted of rape by Justice Marvin Zuker in a Toronto courthouse. The conviction is now under appeal and will, I hope, be overturned. For now, however, it is important to look at the words of Justice Zuker to get a picture of how feminist theory is transforming the adjudication of rape cases. Zuker's judgment is a word-perfect application of feminist thinking on rape, particularly the idea that male sexuality is about power rather than desire, and that therefore nearly any sex, even involving no force, no inequality, and no coercion, can be rape, depending on the plaintiff's state of mind. Justice Zuker repeats the feminist theory of rape as being about power and control on multiple occasions in his judgment. Three major planks underpin the theory of rape as men's way of controlling women, all present in Zuker's judgment, all contributing to the likelihood that in the absence of evidence, women will consistently win guilty verdicts against men. First, over the past 30 years, feminism has moved away from emphasis on stranger rape to an increasing emphasis on rape between intimates. First with the idea of date rape in the 1990s, and now in instances like the Mandi Gray case, where the actors have been sexually involved with one another for some time. What this has done, of course, is to vastly increase the number of sexual interactions that can be seen to be rape, and to make determining guilt beyond a reasonable doubt far more difficult under a system presuming innocence. I don't know if it is merely a coincidence that just when DNA technology was changing the nature of criminal investigation, feminists began to focus ever more intensively on he said, she said cases in which DNA is of no help. In the case of Mandi Gray and Mustafa Ururyar, Justice Zuker cites a 1991 British House of Lords statement affirming that rape is rape, whatever the relationship between the accused and the accuser, even if the accuser is the man's wife. The woman always has the right to withhold or withdraw consent. Now, any reasonable person will agree that it is possible for a man to rape his wife. However, a reasonable person would also, I believe, find it untenable that partners in an established sexual relationship must always obtain explicit consent. In most such relationships, consent may be simply understood. This is where the feminist theory of affirmative consent, which is cited many times by Justice Zuker, turns all sorts of sex into rape. Quote, affirmative consent must be ongoing throughout a sexual activity, end quote, according to Zuker. And on this basis, he finds Ururyar guilty beyond a reasonable doubt. He doesn't say how Mr. Ururyar was to know that Ms. Gray, previously a willing sexual partner and only a few hours earlier having issued an explicit invitation to hot sex, how he was to have known she had changed her mind about the sex if she didn't tell him. According to Justice Zuker, the fact that she, quote, stiffened, as she claimed, and said nothing should have prompted him to query his partner. Well, perhaps in an ideal world, but rape law should not be concerning itself with a man's failure to meet an ideal of romantic conduct It's supposed to be about crime. According to Zuker, a crime definitely occurred. He says, quote, "It is the personal responsibility of each person involved in the sexual activity to ensure that he or she has the affirmative consent of the other," end quote. But anyone who thinks about it for a minute will know that one can never ensure this, even with constant libido-quashing inquiries. Is this okay? Is this okay? And on and on. There's always the possibility that lack of consent could occur 1 millisecond after an affirmative, and then you're in a rape situation because, according to feminist dogma, quote, "silence or lack of resistance does not demonstrate consent." That's another quote from Justice Zuker. Is this judge for real? Wouldn't it make far more sense to say that it is each person's responsibility in a sexual interaction to clearly communicate non-consent, if that's what they feel? That's far more straightforward. You just say no. But Zuker isn't interested in the woman's simple responsibility to say no, only in the man's impossible responsibility to affirm yes at every stage. This means essentially that every man is always already a rapist unless his partner decides that he is not. To strengthen women's power over men, we have the second plank in the feminist platform. Feminists have applied trauma theory to their understanding of rape. Such theory explains any inconsistencies, outright contradictions, or general implausibilities in the rape accuser's story as arising out of her trauma. Therefore, nothing the woman says or does can be seen to weaken her credibility. This is a perfect circle of illogic because it means that anything that might be brought forward as contextual evidence that the woman was not raped, for example, that she herself didn't think she was raped, that her story changed over time, or that she lied to the police, well, now those very things are not only not evidence that she's lying about the rape, they are actually evidence for her rape trauma. And Justice Zuker buys this completely and uses it to excuse memory slips and other doubt-inducing behaviors on Mandi Gray's part, such as the fact that she deleted the text inviting Mr. Ururyar for hot sex and didn't mention it to police. That's okay, according to Zuker. It's an example of what he calls, quote, counterintuitive victim responses to trauma, end quote. And he duly cites trauma theorists to support his position. So it's a double whammy. Any sex is potentially rape, according to feminist theory, and any complainant, no matter how implausible, is a survivor of trauma, precisely because she is implausible. Finally, the third major plank. Feminist theorists have been working for the past 30 years to develop their theory of patriarchal power as something so far-reaching, so amorphous yet ever-present that even a highly educated, presumably confident and mentally capable, certainly successful, sexually liberated white woman like Mandi Gray is supposedly helpless before it. This is why Mandi Gray couldn't say no to Mr. Ururyar, couldn't have changed her mind about going into his bedroom and getting into his bed, couldn't have said, please don't, when he initiated oral sex. She just went along because she was so helpless. Justice Zuker has no problem with that either, and in fact, in relation to this aspect of the so-called rape, he wrote what is perhaps the most bizarre and outrageous paragraph of his entire 177-page judgment, in which he suggests that the law itself needs to change to treat women differently from men because women are so crushed by patriarchal power that they are not actually autonomous agents. Take a deep breath. Here it is. Quote, "The question, why didn't she leave, is actually an objectifying statement that asserts that the woman did not leave. Asking this question often makes actual separations disappear. Law assumes, pretends, the autonomy of women. Why didn't she leave implies the woman could have left. We need to challenge the coercion of choices, reveal the complexity of experience and struggle, and recast the entire discussion of separations in terms of violent attempts at control." End quote. The statement, like much feminist theory, doesn't really make any sense, and Judge Zuker seems to have forgotten entirely about the specific case of Mandi Gray and Mustafa Ururyar as he floats off into some kind of impassioned cry for battered women. But still, the import is clear. According to Judge Zuker, women have been so oppressed by patriarchy that they can't actually say what they mean or act with integrity, and the law can and should be warped by a judge in order to accommodate any woman's story of victimhood. That a judge can actually criticize the law for assuming the autonomy of women, as he says. That he can say that is, to say the least, startling. What would it actually mean for the law not to assume female autonomy? Would it mean women couldn't be held responsible for crimes? Would it mean women's words and actions couldn't be understood as reflecting rational agency? If taken seriously, Justice Zuker's feminist proposition would surely mean a woman couldn't enter into any binding legal agreements, couldn't sign contracts, and couldn't assume positions of legal responsibility or power. I don't know precisely what Justice Zuker meant, but it is shocking that such abstruse pseudo-academic reasoning can be used to convict a man of a serious crime based entirely on a woman's word, even though supposedly women are so powerless that they can't be expected to say what they mean when it really matters. So this is what feminist law looks like. Hideous.